Blount County Bar. I would like to reserve 3 minutes for rebuttal.
3?
Yes, sir.
That'll be fine.
Thank you, Your Honor. Your Honor, this is one of those cases that is of utmost importance anytime we deal with parental termination cases and adoption. This is a particular case, though, where there is a multitude of errors that I believe sets it apart from other cases that this court has looked at. Your Honor, I know that you, as Chief Judge, previously authored an opinion in Re Natalie S., which I cite in my brief, but I hope to distinguish this case from the ultimate holding in that case. In this particular case, I represent the mother who lost on the termination case. Previously, she and the father were unmarried, lived together. They produced a child. Both of the parents, at some point during that relationship, had experimented with illegal drugs. Ultimately, the parents split, and father began paying child support after a court hearing to mother. Ultimately, mother became addicted to drugs and went into a downward spiral. Mother's grandmother, her name is Gypsy Finley, actually contacted the father in this case and said, "You need to do something. This child needs you to step in. My granddaughter's not at a good place." So my client's own mother or grandmother took action because she loved this little girl so much and wanted to protect her. And so Dustin Braden, the father, did file in juvenile court in Knoxville alleging that the child was dependent and neglected by mother's behaviors and her drug addiction. The little girl at this time was kindergarten age, and father did, in juvenile court, get custody. At the trial, Gypsy Finley appeared on behalf of father, testifying and being willing to testify against her own granddaughter. During that time frame, father first filed this petition in late 2014, 2015, and ultimately father had full custody in this case. The mother appeared at the final hearing and admitted to dependency and neglect based upon her time in jail. She had been in jail just under 3 months in Blount County, Tennessee in 2015, and her situation. So mother at this point was on supervised probation out of Blount County for more than a 2-year period that she had to serve on supervised probation. Unbeknownst to mother, during this time that she was under the juvenile court order, the father did in fact file a petition to terminate. This is where the cascade of deficiencies began. There was improper service upon the mother. They attempted to serve her by publication. And they did it in the wrong county, and there was no affidavit of diligent search filed by father showing that he had tried to find mother's location. Now, I will point out another deficiency at this point that exists is 2 months before the father filed his petition to terminate and adopt. Dustin Braden, the father, was also represented by another attorney, in addition to Ms. Anderson, in Knoxville, in Knox Juvenile Court, and there was a child support order that went down in August of 16. It's relevant for a couple reasons, but the one I'll mention right now is if we look at that certificate of service, and it is in Exhibit 5 in the record. The certificate of service lists 2 addresses for mother, both of which were in Knox County. However, 2 months later, father files his sworn petition to terminate and adopt, alleging that he didn't know where mother was and that her last known address was in Blount County. The facts of the case show that she was only a resident of Blount County, if you want to call her that, when she was in jail for approximately 2.5 months. So father starts off this whole scenario by being dishonest in his petition. He alleges that he didn't know where she was, so there was improper service. Mother did not know this went on. She still thought she was operating under the Knox Juvenile Court order. That placed her on supervised visitation and gave her a whole litany of requirements to do if she ever hoped to get unsupervised visits back. The case in Knox County was ultimately transferred to Campbell County by court order. Mother did not know that father had filed the petition to terminate in October of 2017. In 2016. The following year, in 2017, mother, so not only had she been not served with this, but she hired an attorney in Knoxville to say, "Help me see my daughter. My ex-boyfriend is not letting me see my child. Mother professed that she had been made numerous attempts, could not find this child, or she knew where the child was, but she could not contact the child, that father was blocking, prohibiting all contact with his child. What mother did not know was that her rights had already been terminated, and the adoption had already gone through. Mother hires an attorney in Knoxville. We reference this on page 7 in our brief. The lawyer, even though hired in 17, did not file a petition for visitation in Campbell County Juvenile Court until September of 18. So the lawyer sat on this case for whatever reason, did not file until 2017, and only after she filed this petition for visitation in Campbell County did she discover that the child had already been adopted by the stepmother. Now, some of the issues in this case, and this is where I think it's important for us to know, there are deficiencies in the petition itself. Now, father and the stepmother signed it under oath, swearing they didn't know where mom was. They also signed under oath that the mother had abandoned the child by not visiting for 4 consecutive months immediately preceding the filing of the petition. And I think that's relevant because the truth of the matter showed that mother's last contact with the child was in July of 16, just 3 months before, not 4. At no point in father's petition did he plead that there was token visitation. He said there was no visitation. Now, there is a discrepancy in the facts of the case. Mother testified that she had visited at least 6 or 7 different times with her daughter under the supervision of Gypsy Finley, the grandmother who first initiated this by contacting Dad and saying, hey, you need to do something. So grandmother Gypsy Finley was the supervisor. Gypsy later testified at trial that she remembered specifically 1 visit. There might have been more, but specifically just 1 visit. Mother testified as to 6 or 7. So it is our position that mother was going through her recovery, that she had been on drugs. There's a period of time she remained on drugs, but that she was having supervised visits as contemplated by the Knox Juvenile Order. And that these visits were not token or perfunctory. They were meaningful visits. She would go spend time. At one of the visits, she actually gave her daughter a cell phone so that the daughter could call mom at any time. Father, when he found out about it, took the cell phone, removed it from daughter so that it cut off that ability to communicate through the child's cell phone. Dad did everything he could to prevent contact. The last visit with mother between her and the daughter while supervised was in July of 16, and the visit ended when father called the police to help retrieve the child because father didn't like the activity that Gypsy Finley had engaged. She invited another child. She invited my client's sister to all go with them to see a child's movie and to have lunch together. Father did not like that they did that without his permission, called the police. That was the last contact my client had with the child. It was in July of 16. 3 months later, he files to terminate. So first, he did not meet the 4-month deadline. He should have waited 1 more month, but he didn't. Secondly, under abandonment is that of child support, alleging that she had not paid for 4 consecutive months preceding the filing of this petition. Of interest, again, I think is the fact that simultaneously there's the Knox County Juvenile Court dealing with child support while father's doing his termination in Campbell County. The Knox Juvenile Court order was signed in August of 16, 2 months before the termination petition was filed. And that order said that mother had a duty to pay. Now, this is a case, I think, what happened there, why attorneys need to timely file orders, because the actual hearing in Knox Juvenile for child support was in August of 15. For whatever reason, that child support order did not get signed by the judge until August of 16, and the certificate of service to my client listed her two Knox County addresses where she had lived. So as far as a court order, the child support order that found that my client had a duty to pay was in August of 16, 2 months before the petition was filed. The chancellor ultimately ruled that on the grounds of abandonment, finding that there was sufficient grounds to terminate, and ultimately found that it was in the best interest. A problem I have with the way this case was handled at the trial level was we also waited until father completed his proof in Chancery Court. It went on over a period of several months, different days, 3 different days, primarily because of COVID and the court schedule. We had a hard time keeping things moving. But at the close of the petitioner's proof, they rested. I made a motion for a directed verdict alleging violations in the original petition. They failed to, even though they signed under oath that they would file, that they had consulted with the putative father registry, they didn't. They did not include Rule 9, which is required language of the Rules of Civil Procedure, to be included in the petition. They didn't do that. They didn't include the statistical biographical information about the child. Now, this court has previously ruled that those issues cannot be overlooked and remanded the case for hearing. But what the chancellor did in this particular case is, after I made my motion for the directed verdict, she took it under advisement. And the case was reset for another period of time. While it was under advisement, my colleague filed a motion for leave of court to amend the petition after the close of her proof. And I understand why she did, because I had made my motion for a directed verdict, and so she wanted to go back and amend the petition. She then, a little bit later, filed another motion to amend the petition, both of which were allowed by the trial court. So part of our defense in this case dealt with these procedural deficiencies. We recognized those deficiencies were there. We waited until the appropriate time where they could not amend their complaint, because I knew if I had mentioned it earlier, it would be likely that the court would allow leave of court to amend. So at the close of their proof, I made my motion. Judge took it under advisement, allowed them to amend, and so basically that cured those procedural deficiencies. I think it's distinct from the Re Natalie case because we have a huge history of deficiencies here, not just the procedural ones, but the service of process, the signing the petition under oath, stating things that were clearly not true. It just on and on it goes. And then my client is also, she's pursuing this, and I'll close up with this one sentence, and or paragraph. She was pursuing this, Your Honor, but her attorney failed her. The attorney she hired to file for visitation in Campbell County failed her, did not file at an appropriate time, did not know the termination had taken place, and ultimately that attorney was disciplined for their failures. So my client has been knocked down, and I'll save the remaining time, Your Honor, just to finish this up, but we believe that it was inappropriate, not only procedurally, but substantively. The grounds just are not there, and clearly not in the best interest for this child to have.
You have your time for rebuttal, counsel.
Thank you.
We'll hear from the appellee.
Thank you. I'm sorry. Yes, sir. Good morning, Your Honors. I'm Christy Anderson. I'm with the Campbell County Bar. In this case, what we have is we originally filed a petition to terminate, and Mr. Shepherd is correct. When we filed that, we alleged that the mother was living in Blount County, and we filed for publication. When we filed for publication, it was our belief that that is where she was living. My clients had researched that. They had tried to contact her, and the last information they had from the mother's grandmother was that she was living in Blount County. The mother had been arrested multiple times in Blount County. She had served some time in Blount County, and she had a boyfriend that she'd been staying with, and he lived in various locations. And so they testified through the trial that they believed at the time that they filed and alleged that they didn't know where she was at, believed to be Blount County, that that's where she really was. Ultimately, the court set aside that adoption, and we started all over. And when we started all over, the mother was properly served, because at that time she had Mr. Shepherd as her attorney, and so she was served, and we proceeded from there. Mr. Shepherd's correct. There were some defects within the petition. We were in our trial, and at the time that we were in the trial, the court, we had multiple resets, like you said, due to various things going on with the court, with COVID. And so it took multiple days to conclude the trial. We filed during that time several motions to amend to allege to correct these deficiencies that we had. We ultimately did file the putative father registry. That was filed prior to the close of the case. And the court allowed us to amend. And as this court's aware, the rules of civil procedure freely allow amendments to be given, because otherwise you can have harsh consequences under the law, and so typically that is something that's freely given. And I might add that during this time, both of the parties, the mother and the father, they both conceded that the father was the father. That was never an issue. It was never disputed. We also, Mr. Shepherd also has alleged that we failed to include the notice, and again, we moved to amend that as well, and that was allowed by the court. We submitted that notice. We also had the other deficiencies. Ultimately, our deficiencies were no different than in Re Natalie RC. Actually, in an in Re Natalie RC, the court found that there were 4 defects in that case. And as this court may be aware, in that particular case, the court said, although we cannot overlook these defects, we believe that these defects can be amended, and we don't think that you can necessarily have the situation where, you know, it's fatal. And the court allowed it to return back to the lower court for that to be done if they so chose. We had 3 deficiencies. They were exactly the same as 3 of the deficiencies within in Re Natalie, and at that time the court found that those things could be amended and corrected, that it was not fatal and should not be a determining decision in dismissing the petition to terminate. With regards to the abandonment, we did allege several grounds. We alleged that there was willful failure.
Are grounds an issue in this case?
I'm sorry?
Are grounds an issue in this case? Were they appealed?
Mr. Shepherd appealed the issue with regards to the abandonment.
Did he specifically list in his?
I believe he did. He addresses them within his brief. He addressed the abandonment issue under
Well,
willful.
he said he was entitled to a involuntary dismissal.
In his brief in this filing,
Yes.
I do not believe that he said he was entitled to a dismissal, but he.
That's not my question. My question is, were grounds specifically raised as an issue in this appeal? I know best interest was, and I know the substantive rulings that the trial court made allowing you to amend, and the question of whether he was entitled to an involuntary dismissal. But I don't recall seeing grounds being specifically raised.
I guess what I would say, Your Honors, I'm not sure that he specifically raised it. He did address the abandonment issue within his brief. I'm not sure how else to answer that question. I don't think he specifically said that he's entitled to an involuntary dismissal, but he did address the issues of abandonment in his brief. And within that, he alleged that the mother had visited more times than we had alleged. The testimony at trial actually showed, through the mother's own witness, her grandmother, that she had visited one time. And that's important because the grandmother was the supervisor of visitation. The visitation that she had was in 2016, in July of 2016. The child had been in my client's care exclusively since January of 2015. And it's important to note that the grandmother saw this child on various occasions. My clients allowed the grandmother to visit with the child, even though there were no court orders regarding that. The mother was allowed to see the child through the grandmother, and there were certain conditions that had to be met for her to be able to see the child during that time. In July of 2016, which was the only visit that had taken place, what occurred at that time was the grandmother was violating the court order from Knox County, which required certain things to be in place, one of which was that no one else could be present during any visitation that the mother was receiving. So when the father determined that the grandmother had allowed the mother and multiple other people to be present, he contacted law enforcement and ultimately picked up the child. That was the only visit that the mother had. The mother testified in court that she had had multiple visits, but she couldn't tell when they were, and she admittedly said that she chose drugs over her child, and instead of having extra visits with the child because she knew her grandmother was seeing the child. She chose to do drugs and not participate in visitation at that time. And the court found that the mother's testimony was not credible. She was a convicted felon. She admitted in trial that she had lied to Ridgeview when she had her assessment obtained, which she indicated she was not taking any drugs and hadn't taken them for some period of time. At the time of trial, the mother was still taking drugs. She was taking them legally at that point, but they were some of the same drugs that she began her addiction with, which were hydrocodone, and she had also added in gabapentin at that time as well. So she was still taking drugs at the time that the trial concluded. She just had them legally at that point. With regards to and the court found she wasn't credible. The court found that she had been untruthful throughout the proceedings with regards to Ridgeview, that she had not prepared or had not been truthful with a lot of things. And so the court, however, found that my clients were credible. The court believed their testimony. My client actually testified that the mother may have even visited 2 times. He was not sure, but he said no more than 2. And that was consistent with what the mother's witness had testified. With regards to the support issue, the child support the mother was served in Knox County while she was incarcerated in Blount County on April the 15th of 2015. The child support order was entered on August the 24th of 2015. Mr. Shepard is correct that the prior counsel did not enter that order until 2016. However, that was nunc-pro-tunc back to 2015. And that was also at the same time that the mother's support that the father was paying was stopped. So she was aware that her support was stopped at that time, but she claimed in trial that she was not actually served with a petition, although there was a summons that indicated she had been served. And she also indicated that she wasn't aware that, that child support had been ordered. The mother, she testified that she had, throughout this time, from the time the child was removed until the time of this petition, that she had worked off and on. She testified that she had lived with a boyfriend who owned businesses and that he freely gave her money, that she spent on average about $180 a day on roxycodone at that time, and that she had done that regularly. At the time of the filing, at the time of trial, she was still employed. She was working for Texas Roadhouse at that time, and she indicated that she had never had any issue with money, that it had always been available. And she also testified that she knew that she had the obligation to support her child, but she didn't. She testified that she chose to use drugs instead of supporting her child. With regards to the best interest, the trial court was very detailed in its ruling on the best interest analysis. The court found in the best interest analysis that the mother had made a significant change with regards to her circumstances. She was living in a home at that time with her husband. She had other children in the home from this marriage, and the court found that she had made that adjustment. The court found that she had not visited with the child. The court found at best that she had had one visit based on the mother's own witness's testimony, which was the grandmother, who was the supervisor, and the court found that to be credible. She did not find the mother's testimony to be credible, that she had visited at least 6 or 7 times. The court found that the one visit that she did have, which was in July, which was not held according to the court order from Knox County, that it was token at best, and that it was nothing more than that. With regards, the court found correctly that there was not that the permanency plan, and that was granted, I think, at the directed verdict that Mr. Shepard had asked for. The court found there was not a meaningful relationship with regards to the mother and the child. The mother had not seen the child since January of 2015 when the child was removed from her care. She had not, the child had not asked about the mother. The testimony was that the child never talked about the mother, that there were never any questions asked about her, and that the child, when she came to live with my clients, she was in a position where she was a nervous child. She cried randomly. She was behind in school. She had a lot of catching up to do. And at the time of trial, the testimony was that the child was very confident. She was an excellent student. She was involved in all kinds of extracurricular activities. that she was well adjusted, and the guardian opined that it would be contrary to the child's best interest for this relationship to continue, or to be reinstated, because the child, the guardian opined that the child would probably need some extensive counseling, that the child had never talked about the mother, and that it could cause some damage to the child if they were allowed to have the visitation. With regards to the factor of whether or not the child had been exposed to any brutality, physical, sexual, emotional, or psychological abuse, the court found properly that the mother had exposed, and it was noted in the Knox County Juvenile Court order, that the mother had been in an abusive relationship, that she had exposed the child to that abusive relationship, and as part of the Knox County Court order, she was ordered to address those domestic violence issues, which at the time of trial she had never addressed. The court also found that the mother, through her own testimony, had been using drugs while she was caring for the child, and that she would use drugs prior to taking the child to different locations. The court did find that the mother's home was currently, an appropriate home. However, the court noted it had concerns that the mother had failed to disclose to the pain clinic that she was currently seeing that she had been addicted to drugs, and that one of the drugs she had been addicted to was, in fact, one of the drugs that they were prescribing to her. So the court was concerned about that, but otherwise found that the home was appropriate. I would submit to this court that the trial court was proper in its decision, and it was very thorough in making its decision, and I would ask this court to affirm the trial court's decision. Thank you.
Thank you, counsel. We'll hear from the appellant rebuttal.
I hope in my haste to go through the facts, I did not mislead the court in any way, but we did in our brief mention and raise the issue of abandonment in issue 1, where we talk about procedural deficiencies as well as, or technical deficiencies, as well as these procedural deficiencies. In our motion for a directed verdict, we did talk about the issue of, in their pleading, they state that my client had failed to comply with a permanency plan. Well, there was no permanency plan. So the court did grant us the directed verdict on that ultimately. But we also talk about the fact that the abandonment issue had not been satisfied. Now, of interest in this case, the appellee wants to state that mom only visited one time, but yet the trial does show that on one of the visits, the dad was upset because mom was showering with the child, her daughter. On another visit, mom gave the child a cell phone. And then again on the other visit, the final one, they went to a movie with relatives, and dad stopped all contact at that time. In the order denying my directed verdict entered by the Chancery Court, in paragraph 2, which is in the file, on the technical record, it's page 41, but the trial court said mother had 6 or 7 visits. The trial court said that in the motion for directed verdict, but then in her final order talks about 1 visit. This shows why allowing amendments to complaints after the close of proof is not appropriate, because it changes the dynamics. We were on notice with the original petition that they were claiming there had been no visitation. That's what we were on notice for. They did not plead that there was 1 visit or token visits. They said no visits. We relied upon that sworn petition that this was going to be what they would argue in court, and it turned out that was not true. There were visits taking place. So,
Counsel, for your time, let me ask you on best interest. Are there any factual findings made by the trial court relative to best interest that you believe the evidence preponderates against?
I do, and I did try to go through that, but as far as the meaningful relationship between mother and child, I would say that it clearly showed that mom had a meaningful relationship for the first 6 years of the child's life. She was the primary parent. She took care of the child almost every day of the child's life. Mother did have the drug addiction, which then interrupted that, and it was appropriate that father got custody through juvenile court. That was the right thing. Some of the things that are very important, though, Your Honor, is the fact that the trial court found that there had only been that 1 visit, but we state there had been continuous visits. Gypsy Finley, who once testified against her granddaughter, was there at trial testifying for her granddaughter, that this was a case of redemption and rehabilitation, that she was a great and wonderful person. We think that it clearly, we're not trying to take this child away from father and stepmother. We want to be a part of that child's life, and for this extended family, including Gypsy family and others, to be able to be a part of this child. We do think the court's ruling on best interest clearly misplaced reliance for father and ignored things that mother had done, ignored the deficiencies that had taken place. There was nothing in the facts of the case that would show that my client's home was inappropriate, that the relationship would be unsafe. She had remedied or rehabilitated concerns. Yes, she had a checkered past, but many of the issues raised by counsel might deal with what mom's visitation should look like, but not on the issue of
Counsel,
termination.
you've used your time.
Thank you, Your Honor.
Thanks to, of course, thanks to counsel for both sides, and we appreciate your oral arguments and your briefs. If you would, let's call the next case, and then we're going to take a very short recess, please.
Mary Cosby Jackson.